Good morning. The hearing session is now open. It forms part of the examination of the Merton local plan. My name is G.J. Fort, and along with my colleague R.J. Aston, we are the inspectors appointed by the Secretary of State to conduct the examination and to report to the Council in due course. The format of the hearing is a structured and focused discussion that we shall lead. So before we go any further, if I could ask participants to introduce themselves firstly for the Council, please.
Tara Butler, Merton Council.
Eben van Westhuizen, Merton Council.
Thank you. Ms. O'Donnell.
Good morning, Kate O'Donnell, Merton Council.
Thank you. And others in the room, please.
Got it. I always have to press the wrong button, don't I? Nick Steiner, Friends of Wimbledon Park.
Clive Hilton, Wimbledon Union of Residents Associations.
Dave Dawson, Wimbledon Park Residents Association. I'll be the first batsman on this team here. Christopher Coombe, Wimbledon Society.
Susan Cook, Parkside Residents Association.
Ian Simpson, Chairman of the Wimbledon Park Residents Association.
Alice Roberts from CPRE, London.
John Rocher, Director of Rolfe Judd Planning, acting for the All England Lawn Tennis Club.
Got there in the end. David Green, LUC, Associate Director of Ecology on behalf of the All England Lawn Tennis Club.
Oliver Coleman, Rolfe Judd Planning Consultant for All England Club.
Josh Thomas, Rolfe Judd Planning on behalf of the All England Lawn Tennis Club.
And just for those who don't know me, I'm Inspector Richard Aston. Good morning.
Thank you. And I'm expecting Ms. Parsons on the Zoom feed as well.
Yes, good morning. I'm Katie Parsons from Historic England.
Thank you. So the programme officer for the examination is Carmel Edwards, and she should be the main point of contact prior to and after the hearing sessions, and should be copied into all correspondence, and she can deal with any procedural queries that you might have when we're not sitting. So now would be a good time to switch off mobile phones or turn them to silent. And before we proceed further, could I ask the Council to give us their usual housekeeping remarks, please?
Fully accessible toilets are available at the ground floor of the Civic Centre, just left of the stairs leading up to this chamber. There's a lift just outside the door if you need to use the lift. There's also a drinking water dispenser on the ground floor here. If you can't see it immediately because it's a bit hidden, do ask a member of the security staff. There are no fire drills scheduled during the hearing hours today. If a fire alarm sounds, either intermittently or continuously, please leave the building immediately by the nearest available fire exit without stopping to collect your belongings. Staff will direct you to the exits and the fire assembly point. If you're unable to use the stairs, a member of staff will help you. There's an induction loop system in this room for people with hearing difficulties. And finally, there's free Wi-Fi here in the Council chamber using or registering for LBM guest.
Thank you. And the gentleman that's just joined us, are you intending to speak at this session? Okay, thank you. Right, the hearing session today is being filmed and it's live streamed on the council's website. I presume everyone here is comfortable with that. Okay, does anyone else intend to film or record the event today? Okay. So the matters to be discussed today are focus questions based on and taking forward the matters, issues and questions documents that we previously circulated and the associated hearing statements that were received. So we intend to take mid-morning, lunch and mid-afternoon breaks if we sit as expected. Inspector Aston and I are tasked with considering the soundness of the plan in accordance with the criteria of the National Planning Policy Framework and also whether it is legally compliant. The hearings are intended to assist us in that regard. In submitting the plan, the Council considers that it is a sound one, and this is the starting point for the examination. So if you are challenging the soundness of the plan, then you have to explain why and what changes might be necessary that will make it sound. We have read and will take into account the hearing statements that have been prepared and also the original representations that were made. So there is no need for these to be substantially repeated. Instead, our aim is that the discussion moves on from those documents and deals with specific questions that we have or areas where further clarification or explanation are required. At times, we may ask for a more general contribution or a summary of your position. And when contributing to discussions, it would be helpful for us if contributors will stick to the matter in hand and refrain from commenting on unrelated matters. So in order to test the plan for soundness and legal compliance, Inspector Aston and I will need to ask questions. You will have seen that we have already been doing this, both in preliminary correspondence, in the matters, issues and questions document that we circulated, and in previous hearing sessions. And both the Council and other participants have responded to those questions that we've put so far. So that will continue today. However, anything that is asked should not be taken as indicating a particular predisposition on our part. So we will normally start a particular topic by asking the Council for a general response before we indicate that we wish others to comment. So for those of you in the room, if you wish to comment, then please indicate this by turning your nameplates on the side. And if you're joining us via Zoom, if you can use a hands up function, please. We may also invite contributions from participants on specific points where we think this may assist with the examination. In speaking during the hearing, we will request that you are focused, concise and specific. In particular, if you wish to highlight certain parts of your statement or other documents that form part of the examination, then it will be helpful for us if you can provide references. So those present in the room should use the microphones when speaking to us. And please ensure that they are positioned close to you when speaking so that both those in the room and those who are joining us on the Zoom link can hear you. So those joining us on Zoom would have to make sure that they're unmuted when speaking to us, but muted at all other times. If any of those joining us on Zoom experience technical difficulties, they should contact the programme officer in the first instance. So it's open to the Council to make further changes to the plan, and we would ask that they keep a record of possible changes that arise during the discussions. Any changes that will constitute main modifications to the plan will be subject to consultation at a future stage. No further representations or evidence will be accepted after the hearing sessions are finished, unless we specifically request otherwise. Moreover, we are not expecting any further written submissions during the course of the hearing sessions, but we may request further material should discussions indicate that that will be useful. So there will be a short session at the end of each sitting day to ensure that any suggested modifications or additional items such as topic papers or statements of common ground that have been suggested during the course of the day have been adequately recorded. So before we move on to the substantive discussions of matter 14 today, are there any procedural questions? Okay, if I could pass over to my colleague, Inspector Aston, who's going to set the scene for our discussions today. Inspector Aston.
Okay, thank you, Inspector Fort. So today we'll be discussing matter 14, which is site allocation WI3. I think I'd like to start by saying that whilst we note there are live planning applications relating to this site and the part of the park situated in Wandsworth, we need to be clear that our task as inspectors is not to determine those applications, but rather to assess whether the allocation in the plan is soundly based for the purposes of national policy. So I would ask this morning that those who are participating would bear that in mind. I also trust that that partly answers the query we received from Ms. Roberts earlier in the week about that very issue. Inspector Fort and I conducted a site visit to the land covered by the allocation on Tuesday, the 22nd of March, and we were accompanied by representatives of the Council and the All England Club. It was conducted in advance of the hearings, as access to some of that land was likely to be restricted in the immediate run-up to and during the Wimbledon Championships. Now, as ever on such site visits, there was no discussion of the merits of the allocation or the soundness of the plan, and its purpose was entirely to ensure that we were familiar with the site and its environs. Now, following discussions today, it may be necessary for us to conduct a further site visit at some point, but we're not yet in a position to give a view on timing for such a visit or whether we would have to be accompanied by the council or any other interested parties. That will be confirmed in due course. So in terms of how we're going to take discussions today, the hearing has been structured to answer our questions on the evidence base, the justification for the allocation, heritage matters, some specific questions on mall aspects, and matters relating to the effectiveness and deliverability of the allocation. And as ever, I'd invite the council to open this session by setting out their general view on whether the allocation is justified in general conformity with the London Plan, consistent with national policy and effective. Would that be you, Ms. Butler, this morning?
It would, thanks, Inspector.
Okay, thank you.
Yes, the council believes that the allocation is in compliance with consistent with national policy, effective, and in general conformity with London Plan and justified. I won't repeat the extensive summary we've done of this in our hearing statements, but I am going to draw attention to a few key points. One is in our hearing statements, in our answer to question 8, we talk extensively about the MPPF and the relationship with the historic environment. In particular, chapter 16 of the MPPF, which talks about plans setting out a positive strategy for the conservation and enjoyment of the historic environment, including heritage assets most at risk through neglect, decay, or other threats. As we know, Wimbledon Park is on the Heritage at Risk Register. MPPF paragraph 206 also states, local planning authorities should look for opportunities for new development within conservation areas and within the setting of heritage assets to enhance or better reveal their significance. That's another key point. So another point as well is that as answered in question 9, as I said, the park is on the Heritage at Risk Register, and we very much believe that the allocation is one of the ways of addressing the 4 matters for the reason it's on the Heritage at Risk Register. I will take this opportunity to just introduce a key point on our evidence. We are we have substantial amount of evidence on this site, but very recently we've been in discussions with Historic England again. And I'm referring to document OD13K, which is the Council's Statement of Common Ground with Historic England on site WI3. And this was prepared in June 2022, so it's a fairly recent document. And I'd like to draw the inspector's attention to the fact that all the modifications proposed on site WI3 are contained within LBM05 and LBM03, except for the ones proposed in this document. There are a number of modifications, we believe, that just tighten up the plan and refer to issues of clarity. But there is one point on our evidence that I'd like to draw the inspector's attention to. At the end of that statement, and in discussions with Historic England have asked the council to pull together the extensive evidence on the historic aspects of the site into a single document. We've been working on this site for many years, since the plan started in 2018. And in parallel, there's a wealth of historic evidence on the background to the site. We've been in discussions with Ms. Parsons' colleagues, Christopher Lane, and others for several years on the historic aspects of the site. But as Ms. Parsons pointed out, it isn't clear in the examination library where this evidence sits, and pulling it together in one document would greatly help her, even though her colleagues have been involved. So in summary, we believe that, yes, the proposal is in compliance with national policy. It is in general conformity with the London plan, as per the statements of general conformity that we've prepared with the GLA. It does have the necessary evidence base, subject to pulling together a single document on this, and it is justified.
Thank you, Ms. Butler. And we're going to move on to the evidence base, as Inspector Aston said, further down the agenda. But in terms of that piece of work that Historic England said is necessary in terms of the evidential basis, when is that likely to be available?
It shouldn't take too long to pull together, but certainly within a fairly short space of time. Do you have a particular timescales, Inspector, that you'd like to see this carried out?
I think it's similar to some of the things we discussed on tall buildings, isn't it? If it's available in good time, so that we can discuss it at stage 2, if necessary, that would be useful.
Yes, that won't be a problem.
Thank you, Inspector Aston.
Thank you. Just on a general point there, I'd like to bring Ms. Parsons in first, because I was going to ask about the allocation and how, based on the 2 documents, the character study and the master plan, and probe some of the deficiencies with that. Because there was a comment in the representations that it wasn't underpinned by adequate evidence and does not contain correct criteria. So I think what I'll do is I'll just invite Ms. Parsons to just kind of comment on what we've heard from Ms. Butler, and then we'll seek some of the views on that around the room, and we'll go from there before coming back to some. I do have some questions for the club. I'll call it the club, you know who I mean, on the master plan, and then we'll come back to that. So Ms. Parsons, please.
Hello, good morning. Thank you. I'll start off with the proposed modifications potentially then. So what we've been in agreement with the council on, and what we've been discussing are several amendments to the policy to strengthen it in heritage terms. So there was a straightforward amendment to the wording. This is to the allocation policy on page 289 of the plan, and it was to amend the wording to better align with the MPPF, which is to secure investment in the former golf course to invest in and conserve and enhance the historic landscape. So it was the introduction of conserve and enhance. We requested another few amendments to make better references to the North Wimbledon Conservation Area appraisal and the views that are specifically identified in that, so that they are they're much more clearly represented in the policy as a consideration for decision makers and applicants. We were able to agree some amendments to better represent the reasons why the site is at risk, and we've been able to introduce wording, proposed wording, which really goes to the heart of why the application is at the why the site is on the at-risk register. And finally, there is an amendment to secure the production of a landscape management and maintenance plan, for want of a better title, to sort of, so we can produce, so there is a produced evidence, not an evidence base, but a statement, an agreed level that all the different landowners can start from when managing going forward. And we think that would be very crucial to dealing with some of the long-term issues. So those are the amendments in our statement of common ground. In terms of the evidence, it is tricky, as you said. There is a planning application, another one. We were consulted on one yesterday which has additional information. We haven't had the opportunity to go through that in any detail at all yet, but we do know an awful lot of robust information exists, but it hasn't been produced by the council, and there isn't anything on the evidence library to show how this policy has been arrived at. So it is tricky, because we know the council does exist, you know, this evidence does exist. The council's been working on it for years. We've been involved for years. We've commented on it. So we think trying to get a topic paper or something pulled in that could be used then to draw direct links between this policy and the actual plan, separate to the planning application. And that's what we've tried to do with these amendments. We think these amendments are necessary for any application that could come in over the plan period, not a current application. So we're trying to sort of separate the two, but with the issue of evidence, that's where it becomes a little bit trickier.
Okay, thank you. If Inspector Fort hasn't got anything to add or to ask you specifically on that point, I would like to maybe bring in the club. I'm not sure who, might be Mr. Rocher maybe, because I'd like to just hear a little bit about the status of the master plan and some of the reasoning behind the allocation, just for the hearing. And also, Mr. Rocher, if it is to be you, to add into that a little bit about the significance of it not being allocated as well, please. So, Inspector Fort, if you have anything else you wanted to ask Ms. Parsons on that before we moved on, please.
No, that's fine, Inspector Aston. So I'll bring Mr. Rocher in. So yeah, so there's 2 points to that. So the master plan and what the status of that is, and secondly, what would be the implications if there wasn't an allocation for that site?
Thank you, inspectors. I'll pick up both those questions, and if need be, I'll bring Justin Smith from the club in direct as well to answer those. The status of a master plan. This does go back a little bit in history. The original master plan for the All England Club, which related principally to the main estate, started in 2013 and was worked on 2015. That looked at improvements and investment very necessary in infrastructure on the main site at that time. That was a master plan that was published. It wasn't published within any policy document. It was an All England Club document. And for our purposes, it was consulted upon in those times back in 2013 all the way through 2015, and included a range of identified projects that needed to be done to maintain the status of the club and the facilities on site, recognising its global importance and its national importance to London. Those projects, very briefly, included the new roof and the remodelling of number 1 court. It included also remodelling of courts and Somerset Road, which is just off to one side of the main club. It also included various refurbishment bits around the site, etc. It, as part of that master plan, also identified some of the challenges that we have on site, not all of which have been addressed, I hasten to add, which are to do with how you manage the flows of people around the site, the status of some of those facilities, particularly towards the southern apex, that which is closest towards Wimbledon Village. And it identified a series of objectives that the club wished to realise across that, many of which you'd expect to do with the status of the championships and continuing to improve that, but also the likes of maintaining tennis in an English garden and the aspects of those things. That master plan continues to still be in existence. The projects, I would say, are about 2/3 of the way through on that site. Some of them have been developed, Somerset Road, number 1 court, but not all of them. As you're aware, then the club have acquired now Wimbledon Park Golf Course. That is a recent acquisition following on the back after the original master plan was produced. The works, and I just go slightly into the planning application. Obviously, the planning application relates solely to the golf course and is an evolution now of that previous master plan. So that planning application takes some of the essence of what was in the original master plan, some of the objectives, they remain exactly the same, and then bridges across Church Road and includes that onto the golf course. Now, this is going to be a continuous evolution. If on the basis, and I won't prejudge, and I know you will not either, that planning permission was granted, there would be an evolution of the original master plan, which would then look again at the challenges that still exist on the main site and how those properly relate to any form of development and use on the other side of the road. So I want to say there was original master plan that has evolved and taken on board what is now the proposals for the golf course. There will be, in due course, as we move forward, a further evolution of that master plan, which will take into account what goes on as well on the main site to also deal with the continuous investment and improvement that will be required there, and also the relationship between the new development, if approved, and that which sits on the main site and the operational aspects. So that is a sort of run through of where we are. And like I say, it is a continuous process and one that is not and won't be stopping anytime soon. In terms of whether or not, what would be the position should the site not be allocated? Well, of course, the site wasn't previously allocated. We have pushed forward very hard for that. And that is for a number of reasons. You've heard already from me about the important significance of the site, the importance and desire of the All England Club to maintain Wimbledon at the pinnacle of sport, not just at the pinnacle of tennis and the Grand Slam events, but at the pinnacle of all sport as one of the major sporting events on the globe. And that requires a great deal of planning. It requires a great deal of investment. It also requires a constant review and upgrade of its facilities, both operationally, for spectators, for broadcasting. Needless to say, broadcasting changes almost by the year. The club must keep pace with all these matters. The allocation is fundamental in that respect, in that it must recognise the principle of a continuous improvement and upgrade of the facilities. And that is why we've pushed for that very carefully over the plan period. And I would go back to say that previously, there was no allocation of this site. Whilst we have gained planning permission for previous developments on the site, they were complicated by the lack of that policy support for the principle of the investment and the recognition of the world-class status of the club. What it meant was that every time a planning application was submitted, we were having to justify all those points constantly to weigh into the planning balance. And you may say, well, why do we need it? But I think it is vitally important that an event which requires development ongoing. And I should point out again, of course, this covers both sites. It includes the golf course, yes, but it also includes all of the existing All England Club land holdings. It is vitally important for us and the club that the need for investment, the need for improvement, the need to maintain the site at the pinnacle of its sport is recognised in planning policy terms to support the development and upgrade as we move forward. I note also, and it is worth pointing out, of course, that one of the objectives of the planning application, but also in policy terms, is the relocation of qualifying. That is something also fundamentally important to the club, not least because the lease on the Bank of England site where qualifying is currently being held, in fact this week, is due to expire, but also for qualitative importance and also for the status of the championships and the need to recognise that need. And that is a point recognised in policy. So again, those aspects are fundamental to maintaining the club, its status, the investment, and therefore that is why we proposed it, and we welcome the council's support for those matters.
Oh, sorry, Inspector, were you about to? You go first because you're in the room.
So it was just a follow up on the master plan point. So as I understand it, so the existing master plan relates to it doesn't relate to the golf course element of the site. Okay. So my follow-up question on that was, how were heritage aspects taken into account in the master plan?
You talk about our original master plan, which covered the main site. I mean, again, it looked at the heritage. I mean, interestingly, the heritage mostly relates to the main site. Precisely on that site are to do with the club and its history, because the club has quite an extensive history at that site in itself, and a rich history at that. We also, during the master plan, considered its context, not least the fact that it sits opposite Metropolitan Land. Metropolitan Land does also sit at the northern end of the site, as does a number of conservation areas on other sides and around the site. So in developing those proposals, we were very conscious at that time of those constraints, of the need to address quite properly those planning policy aspects. At that time, it did not focus on the golf course because that wasn't part of the All England Club estate. So it was very much focused on the existing site heritage and importance, but recognising those which sat around it and those heritage assets that sat around it. I mean, obviously, and you'll be aware, of course, that extensive heritage discussions have been going on since that time in relation to the expanded land holdings. And in fact, I would just say that very extensive investigations to properly understand all those matters have been undertaken by the club. They've been shared as part of the planning application. I realise that's not under consideration here, but have been shared in numerous discussions since that time with both Historic England, but also with the council. And a lot of it's also published as part of the planning application. And also the club have an old database which does provide all this information as well.
Thank you. Inspector Aston, your question.
It was just a couple of things. The first one was in relation to heritage. So thank you for that. And thank you, Mr. Rusher, for that kind of broad outline for the hearing. We do have some follow-up questions on that based around some of the comments you've made about kind of development on the golf course and not inappropriate, etc. But that comes to the point of effectiveness. So we will come back to that. I think before we just invite any views or pass over to Inspector Fort to see if anyone in the room wants to comment on what we've heard. And in doing so, that is just about the kind of this point about the justification for the allocation and the evidence base. So if anyone in the room had any comments on that, now would be the appropriate time. But just a quick question that I should have asked at the start. We're mindful of what was said about the outset about our role in respect to the examination of the allocation, obviously, and obviously we know the applications relating to the site were due to be determined from June onwards. That's in accordance with the council's hearing statement. Ms. Butler, could you just clarify a very straightforward question? Was this one that went to, I think it was planning committee last week?
No, it wasn't, Inspector. The application 21P29, no, sorry, is it 20 or 21P2900, as referenced in various statements, has just received some additional information to the council in response to all the representations raised at the first round of consultation. I've checked with my development management colleagues, and the additional information provided by the applicant will be subject to public consultation for 30 days. I think that starts, Ms. Parsons referenced it, so it must just have started. And then the application will be determined after that point.
Okay, thank you. Thank you for that update. Inspector Ford, was there anyone in the room who wanted to invite views on this point about the justification?
Okay, so thinking about the justification, particularly what we've heard in terms of the heritage evidence, we've heard that the council and Historic England now we're of the view that that evidence should be better articulated and provided on the examination website. But is there any further views? Mr. Simpson.
Thank you very much, Mr. Fort. It's already been mentioned before that tackling the whole aspect of this plan has been very difficult to ascertain detail. And having read closely through the MPPF and the London plan not so closely, it does seem to me that there is a deliberate attempt to undermine the protected status of the golf course. No case is made for extending the allocation of the east of Church Road. In fact, all the drafts of the plan until the modifications requested by the council in this process suggest that it was intended to relate only to the land to the west of Church Road. In the draft local plan submitted to the inspectors, there was much confusion as to whether WI3 was originally intended to be just the site to the west or to include the site to the east of Church Road. WI3 was originally shown at stage 2, October 2018, to be the All England site to the west of Church Road. And on the 20th of December that year, Rolfe Judd, on behalf of the All England, proved that while mentioning that their client was in the process of acquiring the golf club, but by stage 2A, 2 years later, the wording of the site allocation remained the same, but the plan included Wimbledon Park Golf Club. Rolfe Judd confirmed that the golf club had been acquired in December 2018 and welcomed the extension of the site allocation. And I would just correct that implication that the acquisition of the golf club had actually been, I think, December 1993. For the freehold. The confusion between site description and site map continued into stage 3. In the planning reports produced for committee meetings in May 20 and July 2021, it was quite clear that it was only the existing All England site to the west of Church Road which was to be included. And we can refer to reasonable reports underlying that. So there appears to be no reason or justification, at least none made public, as to why the site allocation was so widened. Thank you.
Would you like to come in?
I make the simple point that it's a 61-hectare site. It has 3 owners, a small bit owned by TfL under the railway bridge. I would suggest the correct way to approach this is to take a holistic view of the 61-hectare park with the owners, discussing that with the community. Having done that, then to do what the All England are suggesting. And they may well include land swaps as well.
Thank you, Mr. Steiner. Ms. Cook.
Thank you. I'd just like to take issue with the point that the master plan in its present form is referenced at all in the site allocation, because to reference it by implication implies endorsement of its content. The actual wording of the description of the master plan at the moment can only be found on the ALTC website, and it's described, as Mr. Rochier has mentioned, as an evolving vision for the future of the whole estate, which aims to provide a framework against which new development will be assessed in order to meet the ALTC's objectives. The ALTC's objectives are theirs, and Mr. Rochier has said that it's been a bit of a nuisance on the main site to have to keep justifying them every time when a planning application comes up, when a planning application has to be made. The difference between the main site and the golf club site is that the golf club site is MOL, and therefore the approach of needing to make a forensic analysis every time in the case of MOL is, in my view, completely justified. What's also an issue is that the wording is sufficiently vague to suggest that whatever the ALTC decides might be its objectives, and whatever the ALTC decides is necessary or appropriate to fulfill them should therefore feature in this public document which will guide planning policy. It's a bit of a tautology, but it seems to me that the uncertainties of that approach, it's what we say it is, in effect, is something of a hostage to fortune. And I don't think it meets the tests of soundness that are required by NPPF 35 for a local plan, in particular, referencing objectively assessed needs and demonstrating proportionate evidence. And on that basis alone, the reference to the master plan shouldn't be justified. And to the extent that the master plan and the planning application are conflated, there's a practical issue, because the impression is given, and it was answered in response to my submission for the PRA by the council, that the planning application and the master plan had been the subject of extensive consultation. Well, I'd take issue with that because I took part in it. What happened was that the ALTC in March 2021, having acquired the golf club 3 years earlier, announced a series of public briefings. Information was drip-fed in 3 stages about their proposals for the golf course site. For the first time, the news about a stadium, 38 courts, 10 buildings, and all the associated infrastructure was only disclosed in April 2021 on a schedule that was due to end with a planning submission in July that year. The planning permission that was submitted, 100+ documents, did not reflect the concerns which were raised in that consultation. And although the website implies that at each stage feedback was listened to and it informed thinking, it didn't. You don't submit a 100+ page document with 100+ documents of thousands of pages 6 weeks after closing 3 briefings to the community. The planning application, and if it is to be the same thing as the master plan, is not something to which the public has actively contributed in any material respect. And on that basis, I don't believe that there's a justification to include it. Thank you.
Thank you, Ms. Roberts.
Thanks. I just wanted to talk about the approach to the park generally, but to the allocation as well. So I suppose what I wanted to say was about how you would approach the plan making in a positive way would be to say, right, we have these issues, which are about the need for the tournament to retain its status. And here are some options for how this might happen. And for example, I might have expected to see an option which said we would continue to use other venues, possibly within South West London, possibly elsewhere, while of course retaining the incredibly special aspects of the tournament as they happen in the current site. So what I probably would have expected to see was some options which would have enabled the tournament and the status of the tournament and all of the aspects of the development of the tournament for the benefit of the people of Merton and Wandsworth, for the benefit of London and also the country, to have been presented in spatial terms and also in justification terms at a much earlier stage, so that there could have been input from the public. But that isn't what happened. And so it seems to me that there can't be an inclusion of these, of either of the sites actually, because what we're looking for with site allocations is to justify development, or not to justify, sorry, to ensure that there is space for development or for protection. And in that case, the appropriate allocation would probably be for the entire park and would be to make sure that it is protected into the future. And just one other thing, which is that, of course, while approaching a local plan development, you're trying to tackle the issues of how to manage the tournament status, but also you're, of course, trying to manage the provision of public open space for local people too. And there are many spaces in London like this park, which although it has a golf course on it, which is a private members club, is in fact there for public recreation. And there's a reason for that, which is that there's a covenant, of course, on the site, which states that it can't be used for anything other than public recreation. So it can't be used for commercial purposes. And of course, that would include stadiums where people watch sport rather than play recreational sport, as it were. So one would have wanted to see some kind of weighing up of the balance between the status of the Wimbledon tournament and, in relation to the park, the golf course, the need to retain that, of course, as public, as a space that is there for public recreation, or at least to take into account the fact that it is covenanted for public recreation, and whether, for example, the council might wish to work with the owners, of course, who are now the All England Lawn Tennis Club, and to work with them to increase access to for public recreation across the whole of the site, the covenant relating, of course, the whole of the site, and so forth. So rather than an allocation which talks about just the tournament, and this is why I asked the question about the looking at the application and the plan at the same time, because of course wherever we end up with the local plan will underpin what happens, will give, as you said in your questions, a clear direction to the people making that decision. And so it's not appropriate in any way to put the site, certainly not the site to the park that retains the park, but almost certainly there's no justification that I can see that has been weighed up appropriately against alternatives to put the whole site in, to put any of the site in. Sorry, thank you.
Thanks, Ms Roberts. Mr Coombe.
Thank you, Inspector Fort. I may ask, if I may, to deal with a couple of points, and please guide me if you think I should deal with them later. We had a conversation just now with Ms Parsons of Historic England, and some very, very recent evidence and material was explained or mentioned by Ms Butler. Would you allow us to come back on that at this point and to ask about it, please?
Have you had a chance to see that material? Could you remind us of the reference, please, Ms Butler?
I think Mr Coombe is referencing the council's statement of common ground that talks about a topic paper, and that reference is OD 13K on the website, but I think he's referencing the topic paper that hasn't been, but it will be pulled together. Is that correct?
Can I explain? I checked on the council website last night. I didn't find a further statement of common ground. I may have missed it. Forgive me if I have. It's clearly arisen in the very recent days when we've been busy preparing for other material. So forgive me if I haven't dealt with that. But I'm more worried that Historic England, who are taking a keen interest in this site, have had these discussions with Merton, and we're only now hearing that we may hear a cohesive and coherent historic assessment of the whole site, and that if you would allow us, perhaps it could come up at the next part of this inquiry so that we will have a chance to interrogate it. And also, if we may, please have a chance to interrogate the statement of common ground, which we haven't, which I can make some points on, general points on now, if you like.
Yeah, I wonder whether paper copies could be made available. I mean, literally, it's quite a short document, so I think perhaps what might be the best thing to do is during our adjournment this morning, if we give you some time to digest that, that'd be appropriate, and then we could come back to that once you've had time to have a look at it.
Thank you, Inspector Ford. That was the first question I had, picking up the conversation a few minutes ago. The second question has to do with the site allocation, which has been discussed by various of representatives for the All England and of my colleagues. And I'd just like to emphasize a couple of small points. Firstly, that MPPF 15 requires the plan to be prepared as a platform for local people to shape their surroundings and to have a contribution to how their surroundings are shaped. When the council issued in October 2017 a call for sites and explained that it was starting on this local plan process, it very specifically asked for site allocations to be put forward. And as we've heard from my colleague here, Rolfe Judd, on behalf of the All England, asked for the whole of the main west of Church Road site of the All England Club to be given a distinct site allocation. You may wonder why it needed that. They've been busy developing it for a long time, and as we've heard, they have their own master plan. And I reminded myself of the regulations that tell us what is the point of a site allocation, and the point of a site allocation in Regulation 5 of the 2012 regulations tells us that it's to allocate sites for a particular type of development or use. I don't think it could be controversial that there is a particular type of development or use currently on the main All England site, and it doesn't seem unreasonable for that to be allocated. As it happens, that same Rolfe Judd submission asked for the whole of the All England site to be excluded from metropolitan open land. I hope we can come back to that. So we move forward, as my colleague mentioned, to stage 2, when we find that the existing west of Church Road main All England site is in the site allocation, WI3. Fine, there's a nice plan for that. Then we move forward. There is no further public consultation. There is no further engagement between the council and the community. And we suddenly find that a plan has been produced which shows the golf course to be within the same site allocation, using the same words for development. No evidence whatsoever has been put forward to back that up. That's a short point on the site allocation.
Thank you, Mr. Coombe. So Inspector Aston, you had some follow-up points on that.
Thank you, Inspector Fort. Before we ask for Ms. Butler's view on this, I think it's important to just say that we are in a hearing session. There is evidence being put to us this morning orally. I accept what was said about the master plan, the consultation. Just set that aside for a moment. But I'm interested in two things that flow from that conversation, or discussion, I should say. The first one is in effect a question about what you've just heard from Mr. Rocher at the club in terms of the justification for that allocation. I think there's a lot of focus on kind of what's happened. I acknowledge that's the case. But are there any views on the justification that we just heard orally from Mr. Rocher? And also as well, I appreciate it was a question I was going to ask on the modifications, but Mr. Coombe has just indicated about the statement of common ground. So I'll park that for now because there will be an opportunity for you to have a look. So if we can just focus on what we heard from Mr. Rocher about the justification for the allocation, and just are there any views on those particular points, please?
Mr. Coombe?
Sorry, this is probably going to be dealt with by colleagues, and it's a very wide-ranging question. The first thing I would say was that in December 2018, when Rolfe Judd submitted that the existing development site on the west of Church Road should be allocated as site WI3, the All England had already made significant offers to the golf club members that it wished to buy out the golf club in order to produce practice and, in particular, qualifying tournament courts on the golf course. And an offer was made to the golf course members accordingly in about October, November 2018, and that was completed in December 2018. So at the time that Rolfe Judd asked for the site allocation, the All England knew very well that the strange auction that had been going on so that it could acquire the golf course was to be completed, and they had their plans in mind. So why didn't they ask for it then?
Mr. Coombe, just following on from that, I want to kind of just step away from some of the mechanics maybe, and some of what should have happened, what happened, what didn't happen. I want to focus specifically on that, the points made by Mr. Rocher earlier about the justification for this, which we all heard. So if we could focus on that, please. And I think might also be an opportune moment if Mr. Rocher wanted to say anything else on that, Mr. Fort, before Ms. Butler and any others.
Ms. Cook.
Sorry, just picking up on the thinking, the distinction between these two parts of the AELTC's estate will have been extremely obvious to you as inspectors when you did your inspection. On one side of the road, you have the existing estate, which has been there for 100 years. Every square inch has been developed within, apart from the open tennis courts. On the other side of Church Road, you have a historic protected park, grade 2 star listed, heritage at risk, and most importantly, metropolitan open land, to have a single umbrella allocation which seeks to identify a set of principles which are to be applicable to a site which has fundamentally different characteristics is wrong in our view. And also to try and recognize that a master plan which is looking to deliver objectives should be a license, or as I said before, a hostage to fortune, which enables the AELTC to put forward what it thinks is appropriate to deliver its objectives, should not be a guiding principle for what happens on the golf course land because of the multi-layers of protection which it enjoys, which do not apply to the main site. Thank you.
Ms. Parsons.
Thank you. Yeah, so just like to make a point to help clarify our position a little bit more in terms of the master plan and any justification. We have issued our response to the planning application and we have raised concerns and don't support the proposals, but nonetheless we do appreciate that the master plan process allowed a considerable amount of new research and detailed analysis to be done on the heritage of the site. So that is where we are coming from in terms of, we know that there is a huge amount of information that exists. We've seen it. We find it incredibly helpful that that's been done. So that was just our point on the evidence side of it.
Thank you, Ms. Parsons. I'm going to bring Mr. Rochier back in, and then I'm going to ask the council for some responses as well.
Thank you, sir. I will try to sort of pick up on a couple of points as well as just the general point. I mean, I will just reiterate again. I mean, the important thing here is to remember the site allocation that we're talking about talks simply about world-class sporting venue of national and international significance with support for continued and long-term investment in all sites to this end and to improve community access, particularly to Wimbledon Park. That is the aspiration, the allocation. In terms of the master plan, just to be clear, I mean, yes, that is an All England Club document, but it is referenced in the policy at present as contextual, I would add. It's in the site description. We certainly don't see that as a template for the All England Club to overall planning policy. It is simply a process that we quite rightly went through with the club to understand the development needs and how that might be delivered. So it is not intended to impose itself upon policy or to supersede policy, just in that way. But I will say again, just to re-emphasize, at the moment, I know the golf course is a separate piece of land holding. It came into the All England Club's control. That land is used already by the All England Club quite extensively. If you go there today, you'll see that hospitality, car parking, security arrangements are all allocated and sit within the golf course. The golf course is not in operation at present. Also, the world famous queue passes through the golf course. It already performs a fundamental role in the operation of the championships. Without that land at present, we could not succeed in the way we do with a world-class sporting venue. So it is already part of that infrastructure. We've referenced the fact that a big part of this is to relocate qualifying adjacent to the main site. That's been thoroughly tested and examined in terms of the best way of delivering that. I would point out that we see no conflict with the principle of qualifying as tennis with metropolitan land or the status of the land as it sits today, subject to a sensitive design. Indeed, the existing Bank of England site where qualifying is held is metropolitan open land, just as a point of reference. So for us, it is fundamental to have a policy basis, not, I should say, to overrule some of those site designations. It is quite correct and proper that those site designations are referenced within the planning policy as something that would have to be addressed. We don't see it in that way. We see it as something which is continuing to support the investment and give confidence to the club to invest in its facilities and improve those facilities as a matter of principle, but recognizing that there are planning policies that would need to quite rightly be addressed by any planning application coming forward, either on the main site or on the golf course site. I would also add that one of the aspects that the club has taken very seriously is the stewardship of the golf course as a registered park and garden, as metropolitan open land, and looking at that. And we do see, we recognise that it's at risk. We do see, and we do agree with the council, that the opportunities to remedy some of these issues that sit on that land to date can be resolved, or can be at least promoted through that planning policy. The absence of that planning policy would arguably weaken those opportunities. So we do see that it's not simply about the tournament itself, it's not simply about the championships and the improvement of that, but also putting in place a framework for the consideration and improvement of the land, and recognising some of those wider objectives and aspirations as well.
Thank you, Mr. Roche. And I think in terms of those supporting uses you mentioned that are relevant when the championship is ongoing, I mean, how many of those actually need planning consent?
We currently have various consents on the site for the temporary marquees, for those structures that go up on the golf course during this part of the year. So there is a series of planning applications that either get submitted every 5 years or every year, depending on which part of the land you're on. Those are all fundamental to the process. If you were there today, you will see them all in play. So each year there is a number of planning applications submitted for all aspects of the operation alongside just standard development.
Dr. Dawson.
Yes, I came with several things to say, but quite a few of them have been said by other people here. I have a long history with this site. I have lived very close by for something like 40 years, and I advised the council on ecology and nature conservation issues in the past. Indeed, I'm joint author of the handbook Nature Conservation in Merton. But what I want to do here and now is to come to an issue which has not come up yet, which was in our attempt to reach a common position with the London Borough of Merton over this golf course. And you've heard most of the reasons why we are concerned that the golf course is included within WI3 in the plan as it is proposed. There are additional reasons why we consider that not to be a good idea, most of which relate to seeing the attrition of metropolitan open land to the west of Church Road. But others will speak on that later, I hope, because that is a precedent, you might say, whereby we see metropolitan open land being eroded in a policy vacuum. In our attempt to reach an agreement with the London Borough of Merton, we see the natural areas of land here as different. You've heard other evidence about that the character of the land to the west is totally different from that to the east. The character to the east is much closer to that of the rest of the Heritage Park, the Grade 2 star Heritage Park. I don't want to make the case in detail here at the moment because there's others who can do that and have been advocating seeing it that way. So seeing the golf course not as on the basis of land ownership and ambitions of one landowner, but rather in terms of the natural disposition of land which comes to us as a result of history. It has a history dating back to the mid-18th century when Capability Brown developed Wimbledon Park for the first Earl Spencer. And it has been open space, unbuilt open space for the entire history since. And as far as we know before, the historic record isn't that good before the mid-18th century, but certainly ever since. We have good maps. We know about precisely what happened. And I don't want to go into all of that history, but it does characterize this land as a natural unit. It is the sole surviving open space remnant of Capability Brown's Wimbledon Park. And it's identified as this grade 2 star. It's in a conservation area for the same reasons. It has nature conservation importance, etc. And you've heard about MOL. So we would see there that it's quite logical. The plan is not appropriate as it stands, with chalk and cheese allocated in one allocation of land. But we wanted to be constructive and forward-looking on this. What do we do? If we take the golf course out of WI3, we have alternatives. And we think that these should be seriously considered as part of the local plan process. The local plan will guide not just the current planning application, which, as you've heard, some people are pretending is a master plan, which isn't. It will guide all future developments on the golf course. And we need some cohesive forward planning, which looks at the whole heritage land. So what policy should apply? In our proposed statement of common ground, our last paragraph sought a new local plan paragraph for the whole grade 2 star heritage landscape. This would involve the preparation of a master plan. Now, this is not the master plan you've been hearing about. There's no master plan there at the moment. There's a planning application pretending to be a master plan. That's not satisfactory, and it's only over part of the site. London Borough of Merton have got an adopted master plan, but it contributes to the at-risk, which is partly because the landowners are pointing in different directions. We haven't anything for the Wimbledon Club. We need to move forward on the cohesive heritage land, and going ahead with WI3 on a bit of it will make the situation worse, not better. So what should we do? We suggest that we take a step back, we write a new paragraph for the local plan, promising to prepare a master plan with proper consultation across the whole heritage land. So it would leave behind the previous partial treatment of the various different land ownerships. You might prefer rather the submission of the Wimbledon Society on WI3, where a site allocation might be applied to the golf course separately, WI3A, explicitly limiting the nature of development there, rather than having this carte blanche to see attrition of metropolitan open land that we're seeing on the west at the moment. So a policy which has been carefully crafted to ensure that built development is purely ancillary to any open space use. A third possibility is to have no site-specific policy, which is where we are now. For the golf course, just leaving development there to be considered under the existing borough-wide policies. We're in your hands here, but we think that there's no doubt applying washing WI3 across chalk and cheese is a nonsense, and we need something different.
Thank you, Dr. Dawson. So I'm going to go to Ms. Butler now. So there's some points, there's some wide-ranging points there that we're going to discuss further. So particularly in terms of effectiveness and consistency on MOL policy. So I wouldn't expect you to go into detail on that. But in terms of the justification points, I'd like to hear your views on the status of the master plan. And I mean, perhaps we'll develop this further, but we've heard some points that perhaps the boundaries not the correct one. Partially because it relates to land, as Dr. Dawson said, that's chalk and cheese, and partially because it doesn't relate to the entirety of the historic landscape, the registered park and garden. So if I could ask for your reflections on those points first, and we'll no doubt go into more detail on them as the discussion progresses.
Thank you, Inspector. There's quite a lot to cover here. I'll try and do it as comprehensively as possible. First of all, on the master plan, we've bandied that term around a lot, and I apologize if it's caused any upset or confusion. In sites, the proposed allocation for site WI3, it was only really meant to be an informative. It wasn't meant to be something that should be taken on board. You'll see throughout the local plan where there are planning applications or discussions on any site, we have included a reference to those applications on this site and every other site that has an application. And that's really as an informative rather than expecting the reader to look at the application per se. So for example, on site WI3, under the heading site description, at the last paragraph, it says, and this is reading from LBM 05, so there is a proposed modification of what I'm about to read out. Page 290 of LBM 05, the ALTEC have commenced the preparation of a new master plan to investigate and identify the future development opportunities for the ALTEC estate and the championships incorporating the golf course. In August 2021, the ALTEC submitted planning application 21P2900 to Merton Council. As I said, that's just meant to be informative, and it's really in line with the MPPF around about paragraph 39, which talks about pre-application engagement. I think that if this is causing upset and confusion, we would be happy to reconsider whether it stays in the plan. Because it clearly is causing disquiet. But it is a fact. It has been prepared in consultation, whether or not everyone agrees on the merits or demerits of that proposal. And as Ms. Parsons said, all that work does contribute to the information that has been unveiled in a much more detailed form than we had before on the historic environment.
I think, sorry to interrupt, Ms. Butler, but in terms of this distinction between the current planning application and the allocation, and we've also heard that actually there's lots of other planning activity that goes on across both of the sites, some temporary permissions, some operational development related to the I'll call it the main site, and they're not all referred to, are they there? So I think this is potentially where there could be confusion, and in terms of the clarity and the effectiveness of the policy, I think it'd be worthwhile to look at a change there.
That's absolutely fine, Inspector. Just a point on master plans. As referenced in Wimbledon Park's hearing statement, there is also, just to confuse matters further, a council Wimbledon Park master plan that was produced in 2018, which is only for the council's land holdings on Wimbledon Park, so not for any part of site WI3. It's not in the examination library, but we can place it there if that's what you wish.
What is the status of that document, please?
It was produced with quite a lot of engagement, and my recollection, although I will have to confirm in writing, that it was adopted by the council, but it wasn't adopted as a supplementary planning document. So I suppose it's a material consideration in planning terms rather than a official planning guidance.
Yes, I think in the interest of completeness, it'd be useful to have that in the examination library, please.
Regarding the 2018 master plan, it did make comments about the blots on the landscape on the west side of the lakeside, which of course is the Wimbledon Club and the All England Club. So it did go beyond land owned by Merton in a small way, but I think an important way.
Okay, thank you. That's noted. Please continue, Ms. Butler.
Thank you. On the point about the allocation, there was some quite extensive points made about the allocation. So I'm just going to talk through, hopefully briefly summarize the chronology of what happened. At stage 1, which was in 2017, October, there was the call for sites consultation in October 2017 to January 2018. The various people put forward proposals, including the ALTEC, and the map at that stage that the ALTEC provided was for its existing estate. So only the existing estate on the west side of Church Road, and also importantly, the site in Rains Park that provides grass court tennis. That's in the allocation at RP5. Just a reminder that we're looking at the estate as a whole. So it's correct to say that the east side, the Wimbledon Parkside, was not proposed by ALTEC at that point. And as a result, in Merton's local plan stage 2, that's OD 17, the site allocation boundary was focused only on the west side of Church Road and the Rains Park site. And stage 2 was October 2018 to January 2019. And in response to representations and ongoing work, by stage 2A, which is the second stage of Regulation 18, the document reference is OD15. Site allocation WI3 on page 282 included both sides of Church Road, and also worth talking about Rains Park site RP5. However, in the summary, each chapter of the 5 neighbourhoods has a summary of the site allocations as a first introductory map. And unfortunately, in that summary map, we hadn't updated the boundary. So on page 276 of stage 2A, that's document OD15, the summary of those allocations still only includes the first, what was represented at stage 2. I have cross-checked the policies map as well as the site allocation, and it does include both land holdings. So it was simply the summary map on page 276 of OD15 that was incorrect. And that is the same for stage 3. So the policies map proposed at Regulation 19, the site allocation proposed on page 282 of Regulation 19, stage 3, OD1, all shows the whole site, but the summary map is still flawed, and we're proposing a modification to update the summary map accordingly.
Ms. Butler, apologies to interrupt. I heard a lot of letters and numbers then, and I didn't quite get the references. If you could just go back to the policies, you made a comment, the policies map, and then you gave a series of references. I think there were too many L's and D's in there for me to get it down. If you could just repeat that, please.
Absolutely. Stage 2, Regulation 18 is OD 17. Stage 2A, again, Regulation 18 is OD 15. Sites with the page references are for site WI3. The allocation is on page 282. The summary map is on page 276. And stage 3, Regulation 19, the reference is OD1. Page again is 282 for the site allocation. And the summary map is page 276.
Thank you.
Sorry, inspectors. Moving on to the other points raised, one was about the heritage at risk. I mean, we believe very strongly that the allocation helps us to address some of the heritage at risk reasons. While it doesn't include the whole of the park, as some representations have proposed, simply because there isn't extensive development that we're aware of proposed on the council's land holdings and or on the Wimbledon Club land holdings. As I think Mr. Coombe said, the allocation should give certainty about what's going to happen, and we're not aware of extensive change proposed on the other land holdings. Some of the reasons for the heritage for the site, Wimbledon Park, being on the heritage at risk register include fragmented land ownership. It includes uncertainty about the future of the site. It includes protecting views, and there's one that I don't have in front of me. Includes the deterioration of the lake. And the reason that the site isn't whole of Wimbledon Park, including the other now two landowners, the council and Wimbledon Club, is because there isn't significant change proposed that we're aware of on those two sites. And I think I just conclude by mentioning that the Altec estate, while it's not a site we are examining now, it will probably come up in October. The proposals have always included consideration of site RP5 in the plan as facilitating the tennis championships. Please let me know if there's anything I haven't covered.
Okay, Ms. O'Donnell's got her hand up.
Thank you. I just wanted to bring up a couple of points about evidence base. I think that was one of the very first questions that was asked. Just very quickly, I wanted to point out that the council's green infrastructure study, which is document 15D1, and also the playing pitch strategy, which is document 14D5, both of these strategies identified and recommended that the Altec site and all of the sites in the Altec ownership should be identified and recognised for their status as international sporting venues. So that information is something that did inform our development of the site allocation. The documents recognise that the Altec sites are bespoke in their land use, and that kind of fits in with the international profile and the sporting reputation. Through our conversations with the national governing bodies, including the Lawn Tennis Association and Sport England, as part of the development of the playing pitch strategy, Sport England are supportive of the site allocation in its as a general site allocation. This is referenced in their Regulation 19 submission that they made to the council when they went through each of the sites. And I also just wanted to point out that we did have discussions with the consultants who undertook the green infrastructure study, because they suggested at a very early stage that potentially the council could look to develop a more bespoke policy and a specific policy just for the Altec sites. This was to address kind of the specific nature of this site and all of their sites in the borough, to look at the form and the function and how ongoing changes could be looked at. And that wasn't something that the council took forward as a specific policy, but we incorporated those features into the site allocation. So I just thought that was something that I want to bring to everybody's attention.
Thank you, Ms. O'Donnell. I've seen there's some people want to come in. I'm suggesting we're going to take a break. There's some things that have been touched on there that I'd like to explore further, and I'd like to have a decent run at it, really. And conscious that people would like to see the historic England statement of common ground as well, which would facilitate the discussions after the break. So with that in mind, I suggest we take a 20-minute adjournment to give people, would that be enough time to distribute those documents, Ms. Butler?
Yes, we'll do that right now.
Okay, thank you. And people feel like that's enough time to read it? Yeah. So if we come back at 10 to 12, so the hearing's now adjourned. Thank you.